Hi, everyone, and thank you very much for joining us. My name is Dustin Saldarriaga. I am a senior associate at Scott Legal PC. Today, we're going to spend some time talking about moving from a non-immigrant visa to a green card. This is a very common topic of conversation between ourselves and our clients, and we'll be focusing on the employment and business green card options. This includes the EB2 and the EB5. We'll also be specifically focusing on options for entrepreneurs. Today, we're very fortunate to have our firm's managing attorney, Kelly Legrand-Wiener, with us to speak. Kelly has extensive experience helping clients navigate from non-immigrant visas to green card options. So we're lucky to have her here to share her expertise and to respond to any questions that come in. One thing to note is that our firm was started on an E2 visa, so the way we approach working with clients is very much shaped by that very personal experience that our founder has had. A few things before we get started. Although we do focus on business immigration, our firm is a full-service immigration firm, so we do handle family immigration cases, humanitarian immigration cases, and everything in between. So don't hesitate to reach out and schedule a consultation if we can be at all helpful on any topic related to U.S. immigration. We will be continuing this webinar series by doing at least 2 webinars a month. These are on a range of immigration topics. We'll send a link, an email at the end of this webinar that has a link where you can sign up for our future webinars. That email will also have a copy of the PowerPoint that you see on your screen, as well as a link to our YouTube channel. And on our YouTube channel, we post our full-length webinars, as well as shorter videos, again, on a variety of immigration topics. So do check out our YouTube channel if you're at all interested. If you have any questions, you can send them in through either the Q&A function or the chat function on Zoom. I will be monitoring those, and I'll either share them with Kelly at the moment they come up, or I'll save them for the end, but we do plan to get through all of the questions that come in. And as I suggested before, this webinar is being recorded and will be posted to our YouTube channel. So without further delay, I will go ahead and pass it off to Kelly to walk us through the green card options.
Thank you, Dustin. Perfect. So let's get started by just talking a little bit about how the green card system works. So there's kind of various ways that you can apply for a green card. This slide talks about just 2 of them, 2 very common ways. So one is kind of through any family relationships you have, and this can include immediate relatives. So, spouse, parents, children. And then preference categories. So there's other relationships, that both green card holders and U.S. citizens, can use to sponsor, their family members. So for example, U.S. citizens can sponsor siblings, although there is quite a long wait for that. So not every, family relationship will result in being able to sponsor for a green card. Many family relationships, that's not the case. You can't sponsor your cousins or, kind of more attenuated family relationships, but there are some where you can utilize, that relationship, to be sponsored for a green card. Immediate relatives are always going to have green cards available to them. So, if you're a U.S. citizen and you want to sponsor and you get married and you want to sponsor your spouse, you'll always kind of have, the ability to do that. Whereas then with preference categories, there's only a certain number of, green cards that can be issued each year in the various categories. So, based on that, there may be a wait. Sometimes depending on which country, you were born in, there can sometimes be a very long wait. So there's something called the U.S. Visa Bulletin, which outlines, when you're allowed to file your, your green card application. So that is, always good to be familiar with if you are going through that, that process in a preference category. Another very common way to obtain a green card is through employment. And so there's a series of employment-based green cards, EB1, EB2, EB3, EB4, and EB5. We'll talk in more detail about many of these. We won't really touch too much on EB4, which is kind of for special immigrant visas. An example is, if you're on an R1 religious, visa and you're switching to a green card, won't really touch on that in much detail, but the others we will go through. And there's, others that are not listed here. So for example, EB-1B, and EB-1C are both, other potential green card options. And, those are covered in other webinars that we do. But, important takeaway, I think, is just that it is possible to get, a green card through, one of several kind of employment options. Some are self-petitioning, so where you're able to actually just file on your own behalf. Some you need to have a company, that's sponsoring you. Some like the EB-5, you're self-petitioning, but, you need to invest into the United States. So each one has their own criteria. And for these, there's also a limit on the amount that are issued each year. So these can also be subject to backlogs, as the family preference categories can be. And again, the visa bulletin, which is published each month, kind of will provide information about when and whether you're able to file your green card application. Perfect. So let's dig a little more into, family-based green cards. So, as I mentioned, there are immediate relative categories, and lots of benefits you can get from being an immediate relative, not least of which the ability to, file right away. So I think that's kind of a huge benefit you're going to get as an immediate relative. So if that situation, does occur, that you're not having to wait in line. You are able to file, if the person's in the United States, you can file, Form I-130 and then Form I-485 together concurrently. Along with that, you can file for employment authorization and travel authorization. And if you're outside the United States for an immediate relative, you would file your I-130 petition. You're going to wait for that to be approved. Once it's approved, it's sent to the National Visa Center. And then you go through the process of, what's called consular processing. So that's where the application is first vetted by the National Visa Center. You send in biographical information and other information that they request to demonstrate that you are admissible to the United States. And then the U.S. consulate in the country where you're residing will schedule an appointment for you. You'll attend that appointment, and if the visa is approved, then you'll be able to enter the United States, and your green card will be mailed to you. So those are kind of the two main processes by which you can get a green card. And that's the same for immediate relatives and for preference cases, in the sense that either you can file an adjustment of status in the United States if they're here in a status that allows them to adjust, or go through consular processing. The difference is for the preference-based categories, so unmarried sons and daughters who are 21 and older of U.S. citizens, spouses and unmarried children under 21 of legal permanent residents, unmarried, sons and daughters who are 21 and older of lawful permanent residents, married sons and daughters of U.S. citizens, or brothers and sisters of U.S. citizens, if the U.S. citizen is 21 or older. These are all the preference categories. And so these are categories where there's likely to be some type of backlog. And maybe even a very, very long backlog. And this is particularly the case, depending on which country you live in. There's significant backlogs in certain countries, such as Mexico, India, China. So good things to keep in mind, when you are thinking about applying for a green card through family. All right, let's dig in a little with the EB, categories, the employment-based green card categories. So, one category, that our clients talk to us about a lot is the EB-1A, and this is for people of extraordinary ability. So people who have risen to the very top of their field and can demonstrate sustained national or international acclaim and plan to come to the U.S. to keep working in this field of extraordinary ability. So, as kind of outlined here, you need to demonstrate either that you have met, one very large accomplishment, Nobel Prize, a Pulitzer Prize, or that you meet at least 3 of the criteria that are outlined here. And so these criteria, as you can see, are generally, focused on how do you prove that you are someone who's risen to the very top of your field. So, evidence of memberships and associations in the field, which demand outstanding achievement of their members. So just taking this as an example, let's say that you are a lawyer and you're a member of a bar association and you pay a fee each year to be a member. So that itself is really not going to be great evidence for the EB-1A. You have to really think about first, have you met the criteria? So that's what they're going to look at first. Okay, you're a member in an association. But then does this association demand outstanding achievement of their members? What can you prove about kind of the process for becoming a member? Like those are the types of things you have to think about for EB1, documentation. So let's say that, there's a very, elite or exclusive, group that requires that people have, processed a certain number of cases successfully, or kind of reached a certain level within the field. So those are the types of things you want to be looking for EB1A documentation. So not only that you meet the plain language of the criteria, but also that the quality of the evidence is such that, it shows that you're someone who's risen to the very top of your field. So a very big benefit of the EB1A is you do have the ability to self-petition. So it's not tied to an employer, which is, I think, a very attractive, kind of option for many people. It's also a great option, for entrepreneurs. If you're kind of an entrepreneur, you've, run many successful companies, but, because of that, you can't really have a U.S. company sponsor you because you're an owner. The EB1A may be a good option for you if you can meet some of these other criteria that are outlined, here. And in recent years, there have been positive changes to the USCIS policy manual that indicate that the government does mean for this category EB1A and also the EB2 NIW, which we'll talk about in a minute, to be used for entrepreneurs, where they don't really fit neatly into some of the other EB categories. In terms of the actual process, two-step process. So there's Form I-140. So that's where you're going to submit all the documentation showing that you meet the EB1A criteria, that you are an individual who's risen to the very top of your field through sustained national or international acclaim. And then the second step is the I-485 or consular processing. So similar to the family-based cases, if you file an I-140 and the category, your EB1 category is current, so there's a visa available and you're in the US in a valid status, then you can file Form I-485 and go through the green card process while staying in the United States. If you are not in the United States, or maybe you need to travel a lot, it's not going to work for you to kind of stay here and wait for travel authorization. Then you can go through consular processing. So this is also the case. Let's say that, you're someone who's, really renowned in your field, but haven't spent much time in the US, so you live abroad right now, then you also may choose to go through consular processing. And so that's where your I-140 is going to be adjudicated by US Citizenship and Immigration Services. And once it's approved, the approval will be sent to the National Visa Center, and you'll go through a very similar process, that the family-based cases do, with the caveat that you're not needing to meet some of the extra requirements that they have. Perfect. So another option, the EB2 National Interest Waiver. So this is also you have an ability to self-petition here. So this is another option, that entrepreneurs in particular, really, really like. There's a lot of flexibility that goes along with it. A few years ago, there was a great case, matter of Danazar, which completely changed the standard of the EB2 NIW. And within that, within that language of that case, it really heavily showed that the intention was, to make the standard kind of clearer so that, people like entrepreneurs could qualify. So as a threshold consideration for the EB2, you have to have either an advanced degree, so a US master's or higher or equivalent. You could also have a bachelor's plus 5 years of post-baccalaureate progressive experience, which would be considered equivalent to that master's. If you don't have an advanced degree, you can also attempt to qualify based on exceptional ability. This is a lower standard than extraordinary ability, which we were just talking about, but still, I'd say still something, where you need to meet the standard of showing that your accomplishments put you, significantly above that of others within your field. So you'll need to meet one of those as a threshold. Then once you've met that, then you can move on to proving, Danazar. So that's the standard of Danazar, which is that you must be engaged in an endeavor that has substantial merit and national importance. So there has to be some type of company, project, something that you're working on, and this can be in many different fields, business, sciences, arts, anything that you can show is going to have substantial merit and national importance. So some things that are relevant, particularly for entrepreneurs, job creation, economic impact or benefit, to a community, perhaps one that has been under-resourced. A benefit in Danazar was they talked about something can have substantial merit and national importance, even if it's not nationally, national in scope. So something can have national importance, even if it is serving primarily one community. For example, if a company is creating a lot of jobs in a community that traditionally, or historically has not had a lot of job creation, that could be said to have national importance, even though there's not a project that's national in geographic scope. So that was a very beneficial change in Danazar. So once you've demonstrated that your petition or your endeavor has national importance and substantial merit, you then need to demonstrate that you yourself, the applicant, are well positioned to advance the proposed endeavor. So these are going to be things like, your resume, your degrees, expert letters from, people in the industry who know of you or have worked with you and can speak about, your experience, evidence of past success in similar industries. For example, if you're an entrepreneur and you've created and sold a very similar type of company, that could be very favorable to show that you have the ability to advance the proposed endeavor. And then the third criteria is that on balance, it would be beneficial to the government to waive the labor certification process. So for entrepreneurs, this is particularly useful because basically they're able to argue that, well, it makes sense to waive the labor certification process because an entrepreneur, an owner of a company it's going to be impractical, really impossible for them to actually get a labor certification approved because, they own the company. And so we'll talk a little bit more about the PERM process next, but in that PERM process, if you're an owner, it's really not going to be feasible to get like go through the labor certification process because the government is not really ever going to believe that there's a bona fide opportunity open to a U.S. worker when you yourself, the applicant, control the entire company and control the entire process. All right, so let's talk about PERM. PERM is the process by which a U.S. employer is going to sponsor a worker for a green card. So very, very common, for people to come over. Perhaps they're on an H-1B, they're on an O, they're on, an E-2, many different things, and they want to live here permanently, and the U.S. employer will support that. So that is the EB-2 and EB-3 process. It's a, three-step process. The first is the PERM. So you're going to, the company is going to need to draft a job description that outlines only the minimum requirements to do the job in a reasonable manner. They want this process, where you're testing the labor market. They want it to be as open to U.S. workers as possible. You get a prevailing wage determination. So the company files something with the Department of Labor outlining the job duties and requirements, and the Department of Labor will tell them, okay, this is the minimum wage you'll have to pay once the green card is granted. Then you go through the recruitment process. So this is where the company will actually place advertisements. The types of advertisements they have to place are all kind of, specifically outlined in the regulations. So if it's a non-professional position, so a position not requiring a bachelor's degree, then they'll place 3 advertisements, an internal notice of filing, 2 Sunday newspaper advertisements in the newspaper of general circulation, and a posting with the state workforce agency. If it's a professional position, then you have to add 3 additional types of advertisements to that. And there's a list of 10 that each company can choose from. So during that process, the company will, a 60-day process at least, sometimes a little longer, the company will actually have to review resumes, determine if there's any willing, qualified, and available U.S. workers for the role. If there are not, then the company can move ahead, file the labor certification. The labor certification can either be approved, it can be denied, or it can be audited. There are certain audit triggers. For example, if the company requires a foreign language, and it's not something like a job for a Spanish teacher or something where it's really apparent that the language is required. If the requirements are outside what's normally required for the occupation. So the Department of Labor has kind of a system by which they determine what is a normal amount of kind of education and experience to be required for any particular job. And if the job is outside of that, that can sometimes be an audit trigger. The company may have to justify using business necessity why they, need these additional requirements. The perm process, you're filing with the Department of Labor, so you're not yet filing with the U.S. Citizenship and Immigration Services. That comes later. So, Department of Labor, once they approve it, once they certify it, which, that whole process that we just went through, the perm, right now is taking, somewhere between 1 to 3 years. And the reason is that you have to go to the Department of Labor for many different things. So one is the prevailing wage, right? That can take 6 to 12 months just to get that issued. Then you're doing the recruitment, that can take 2 months. Then, you do the actual labor certification filing. Right now, those are taking, somewhere between 8 to 11 months. So there's kind of some periods of time where you're really just waiting to hear back from the Department of Labor. So you need to build that in, to your expectations about when you'll get the green card. It is obviously the case that processing times can change. They can get better. They have been better historically over time, but this is what we've been seeing for the past few years, especially since COVID. Once the labor certification is certified, you can go ahead and file the I-140 petition. So that's the company's petition where they say, we want to sponsor this worker for this position. You'll include proof that the company can pay the prevailing wage, and you'll also include proof that the applicant themselves meets the requirements. So if the minimum requirement is a bachelor's degree and 1 year of experience in a relevant field, you'll include the bachelor's degree, and the credentials evaluation if it's a foreign degree, and then you'll include an employer experience letter outlining the 1 year of experience. For the green card part of the application, you can file an I-485. You can also go through consular processing. For this particular process where people are generally already working for the company in some other status, very often they're going to go through the I-485 process where you file for your green card from within the United States because that's where they're living, that's where they're working. There's obviously circumstances where you go through consular processing instead, but either one is available. In terms of the timing, as we've been talking about, you have to go back to that visa bulletin, see if, your category is current. Are you able to file, or do you have a priority date that's early enough that you can file? And your family members can also join you in this application. And that's also the case, for the EB-1A and the EB-2 NIW. So your family members, your spouse, and any unmarried children under 21 can apply for the green card along with you. All right, so let's touch briefly on EB-5. So EB-5 is a little different than the other EB categories. Although it's under the employment, green cards, really it's an investment, green card. So the main thing, you need to invest either $800,000 or $1,050,000 into a new commercial enterprise. There were, lots of changes to the program that happened in the recent past, including changes to the way that they calculate targeted employment areas. There were also some very favorable changes, where, it used to be that you had to file the I-526, the first form, and then wait several years for approval. Now there's an ability to concurrently file the I-526 with a green card application. So to stay in the United States, assuming the category is current, in your, based on kind of your nationality. There's some, backlogs for people who are born in certain countries, for example, India. So in terms of, what investment can be included, definitely a good thing to talk to an attorney about. There's certain things that cannot be included, legal fees, admin fees, so if you are doing a regional center investment, then generally you're going to, invest the entire amount directly, into that regional center, which is kind of a more passive way to get an EB-5. You'll likely also need to pay admin and legal fees. You have to show the source of funds for that, but you can't include that as part of your investment. And then if you're doing a direct investment, where you're investing the money yourself, perhaps in your own business, you need to talk to your attorney about which fees can be included. Legal and admin fees, again, are not going to be included. It is a situation where you can have kind of investments made over time. But if you're going to do that, you really need to be very aware of what is the source of funds for everything that you're spending, because the government is extremely, extremely particular about the source of funds for EB-5. They'll go back decades. Every dollar needs to be accounted for, and there needs to be a very clear trail for everything that you spend. Also important to flag, retained earnings are not considered EB5 investment. You would need to, like let's say you own your own company, or you're on an E2, you're interested in an EB5. Retained earnings are not going to count as investment. You would actually have to pay yourself that money, be taxed on that money as your personal funds, and then reinvest that money into the company. So something that, definitely good to keep in mind. The E2 investor visa is a temporary visa, and then the EB5 green card is a permanent green card that allows you to live in the United States, and eventually become a U.S. citizen. Some key differences between them, for the E2, the investment amount, there is no investment amount set by regulation. You can invest whatever is substantial, and you can basically have a lot of leeway to argue, what are the startup costs for your type of business, because you are if you're positioning a startup in a certain way, you have a lot more leeway in terms of how much to invest. Additionally, there are certain things that, sources of funds, you can have multiple sources of funds, many things, kind of definitely easier to meet the source of funds requirement for E2 than for EB5. The investment amount can be lower. You can get, it's a temporary visa, and you can get it, depending on what your country of nationality. Many countries can get the visa for up to 5 years, and it can be renewed indefinitely. There's other places like Bangladesh, for example, people from Bangladesh can only get the E2 visa for 3 months. But when they enter, they'll get 2 years in E2 status. So, and a good thing about the E2 also is, as long as you're continuing to run the company and it's continuing to meet the E2 requirements, you can renew it indefinitely. For the EB5, it has an actual investment amount that is set in the regulations. There's no flexibility there. The source of funds requirement is significantly heightened for EB5 over what's required for EB2. So you really need to keep that in mind when you are determining, if you want to go from E2 to EB5, you really need to plan for that ahead of time. Talk to your attorney so you're not kind of investing money and then realizing later, hey, that's actually not going to count. I'm not going to be able to, provide a source of funds for that, or I'm investing in something that's not going to count for EB5. Challenge for EB5 direct investors. As I just talking about, the source of funds is nothing like the E2. It's just so much more involved, so much more in depth. You'll have to provide, many, many years of tax returns, no matter what. They're going to really investigate exactly where that, where those funds came from, any funds that they're seeing as part of the EB5 investment. Another, thing for EB5 is, if you're wanting for an E2 and you purchase a business, so you buy a business from a seller, that's perfectly fine for E2. That will work well. That won't work for an EB5. So if you are purchasing a company and you pay money to the seller, that's not going to count as EB5 investment. Another requirement for EB5 is job creation. So for EB5, the way that it works is you'll file with proof of your investment. You can also, maybe concurrently file your green card application if that's available to you. And then once all of that is approved, you'll get a conditional green card. And in order to remove the conditions, within 2 years, you'll need to file with proof that you've created the 10 full-time jobs and sustained the investment. So that's on form I-829, and that can take several years to process in itself. But let's say that you get to the stage where you're getting your green card, but the business has not created any jobs. That's going to be very problematic. You may not be able to see the process through, because it is a requirement for the EB5 that you have those 10 full-time jobs. You can often submit with a detailed, business plan. I think that, for regional center investments, really, they're going to provide this information to you. For direct investment, it's, you'll need to provide the information, W-2s, proving that you've, created these jobs in the way that you're required to. And then in terms of the forms, I think I've touched on this, but for the EB5, there's the I-526, which is the source of funds and proof of investment. The I-485 or consular processing, that's the green card. And then the I-829, and that's the petition to remove the conditions on the green card. And after, if that's approved, you'll get a 10-year green card, which you'll be able to renew, indefinitely, as long as, you're not, committing any crimes that would make you inadmissible. And you eventually have the ability to become a U.S. citizen. So let's touch really briefly on some other green card options. As we discussed, family and employment are kind of only two of the ways. Another way that you can potentially apply for a green card is through the diversity visa lottery. So this is, you can go online and submit an application depending on if you're from a country that has kind of limited immigration to the United States. So each year they'll publish the list of eligible countries, and you can see if you're eligible and submit an application. Many people will do this, on their own. I'd say the important thing is just to make sure there's many kind of different kind of websites out there that purport to be the official websites. You always want to make sure that whatever, whenever you're submitting that information, that it's the actual government website that's administering the diversity visa lottery program. If you are selected, then you'd have the ability to, apply for a green card. There's not a guarantee that any green card, that you'll get a green card through this process, but it is, worth doing, something that, can work for many people. And your green card just has to be issued before the end of the fiscal year. And you have to meet some other requirements. Obviously, you can't be inadmissible. You don't have to have graduated high school, so those types of things you all want to look at before applying for the diversity visa lottery. There's also green cards that you can get, based on humanitarian circumstances, so asylum, cancellation of, there's many things that, if you've had, kind of issues, kind of in your home country, you may be able to pursue those avenues of relief. Also special circumstance green cards. So, for example, the U visa is something that you can potentially get, which will eventually lead to a green card, although there are significant backlogs for that. And then finally, there is, always the potential for immigration reform, doesn't seem likely in the near term, but it is something that I think, many, kind of immigration advocates and the American Immigration Lawyers Association are constantly kind of advocating for immigration reform to, increase the number of green cards issued each year and, to find other avenues of relief. All right, so just, to other considerations for moving from a visa to a green card. So, timing. So, in many of these slides, we've talked about how long it can take for any specific, process to go through. The first part can take between 1 to 3 years, and that during that time, that doesn't give you any particular status. So you want to keep that in mind, particularly if you have family members, your children, who you're worried about kind of aging out, turning 21 and not being part of your application. You want to think about that. EB-5, taking a long, long time, several years for the EB-5. So, now that there's an ability to concurrently file for the green card, there are some better options for people, but we also have to think about the country specific quotas. So you always have to look at the visa bulletin and see, is this category current based on where I was born? So not where you're a national of or a citizen of at this point, but where were you actually born? And that's going to control for the country specific quotas. Also, with any green card process, you need to think about travel and your visa expiration. So, do you need to travel abroad? How frequently do you need to travel abroad? When do you need to travel abroad? What type of visa are you on? If you're filing an I-485 in the United States, then generally for many people, you're not going to be able to travel once you have filed the I-485 until you get a travel authorization document, and that could take months. If you're on an H-1B visa, if you're on an L visa, these categories have some, special benefits. So you may be able to travel on those, so good thing to talk about with your attorney. But let's say, you're on a TN visa and your employer is sponsoring you for a perm and you're at the I-485 stage, once the I-485 is filed, you can't travel on your TN, you'll have abandoned your, your application. So it may be that you do consular processing if you need to travel a lot. It may be that you time the renewal of certain visas or you time the travel, or certain life events in a particular way to account for the green card process. Another thing you need to consider are kind of the dual intent. So, when do you file for your green card? Are you entering the US, for example, if you enter as a, B2 tourist, you don't want to the next day file a green card application because you've just entered and represented that you're coming, you have a temporary intent, you're coming in as a visitor. And then to file a green card application shows that you actually have permanent intent. So, there are some visas that allow for immigrant intent. So the H-1B, the L, The O and the E have kind of lower standards for intent, but are not full dual intent visas. But definitely things to keep in mind. What type of visa are you on? Like if you're on an H or an L, then the timing of filing your green card application is going to be much easier to figure out, than if you're on a TN. Um, Another thing, you can think about with your green card is you can go through parallel strategies, right? There may be people that, are interested in, the EB5 investment, but it's kind of a long-term, goal, and they're kind of doing that over time. But the company grows enough that they are now eligible for an EB2 NIW. So there's kind of many circumstances where there might be a couple avenues open to you, or perhaps you are going through the EB5 process, or the perm process, and then, you find the love of your life and they're a US citizen and you get married. Now you may want to switch, you may want to go through that process. So always good to keep in mind that there may be multiple options available to you. And, you can discuss with an attorney about, which one is the best one to pursue, or is it good to pursue a few? Sometimes people feel more comfortable relying on their employment. Sometimes people feel more comfortable relying on their family relationships. I think, a key takeaway is just that planning is very key. The green card process takes a long time. There's not kind of a very quick, process, even for the petitions that can be go through premium processing, like the EB1A and the EB2 and IW can go through premium processing for the I-140. You can't really, it's very difficult to expedite the actual green card application part of the process. So, at a minimum, usually you're looking at, a year, before you're going to get your green card, again, at a minimum. So you want to be building that into your thought process, that it's not going to be a matter of just, oh, I'll file some things and a couple weeks later I'll have my green card. You really need to be thinking strategically about it, and planning in the long term. All right. So I think we've reached questions and answers. And Dustin, I'm
Yes.
not sure. I think we're
Yeah,
all
no,
set.
I think you have addressed all questions because we had only a few and they were addressed in the presentation. So thank you so much, Kelly, for taking the time to share your experience and expertise and knowledge. Thank you to our attendees. Please do keep an eye out for that email we will follow up with, which will contain a link to the recording, future webinars, and our YouTube channel. We hope to see you in the future and stay well in the meantime.